Good morning, everyone. I'm Sunny Boren, here to talk to you about LLCs, etc. I hope you're having a nice morning and weren't too cold during the night. I understand that Mammoth's getting down to 20s. We're at 50s, and that's still super cold for me, even the next Coloradan. So the title for today is Safeguarding Wealth. New laws and liability. So here's our agenda. First and foremost, fundamentals of an LLC. Some tax decisions you get to make if you choose to form an LLC. An important trick, workaround of Prop 19, a public service announcement that I want to give you regarding corporate transparency. There's a relatively new act that is becoming effective. We've got some case studies on LLCs, and we'll talk about how we can help. So I think most of you have at least seen pictures of our attorneys, but here we are again. Mark O'Brien is our newest attorney, and he's a hotshot trust administration litigator. Elaine Alston is the second most recent, and she's all civil litigation. So understand we've got broad abilities here now today. And then our two of counsel at the end. Our wonderful staff, our family, who is here to serve you. And a reminder on our full state offices, basically, starting with Santa Cruz, over to Sacramento, down to San Diego. We have got you covered for estate planners, at least, to meet with you. I'll do it too if you really need me to. By doing it, I mean go to the office closest to you. So, as I said, fundamentals of an LLC. Protection against liability, litigators and creditors. Not all creditors. I won't help you use an LLC formation to avoid an existing creditor. That would be a fraudulent conveyance when you transferred assets to the LLC. So that's not a good idea for you. You'll lose in court, most likely, if you would do that. So a limited liability company, biggest step, biggest picture is the newest entity in the various states. It's not that new anymore, but they're so widely known that they're just quickly abbreviated into LLC. LLC is a great shield of protection for you. And insurance salesmen say, insurance can limit your exposure, liability insurance. But I say, why be exposed at all when you've got this cheap of a strategy to give you fabulous protection if you're careful to maintain the LLC properly every year? So as for who should consider using a limited liability company, rental property landlords are primary in our practice. And we've got our gloves on here to protect you. Other business owners, small businesses, licensed professionals, doctors and lawyers and such, per Willie Nelson. Consultants can protect themselves against professional liability in addition to their E&O insurance, errors and omissions. And finally, independent contractors. The when of consideration of this formation is early on, before your business earns a profit, it says at the bottom, and before an accident or lawsuit puts you at very specific risk. And now, increasingly, the middle bullet, it's a good idea to form an LLC before you purchase the rental property or start the business even. But on the rental property, it's important for a Prop 19 reason for your future gifting to your kids. So here's my nest egg slide, and this is my favorite because your nest egg is so important to your future. And I know that you know that. All of your assets, your investment accounts, your normal bank checking or savings account, vehicles, your home, all that you've got is your nest egg that we are working hard to protect when you hire us. An LLC has as good a protection now as regular corporations without the hassle of annual minutes. Just a side point on that. When some small business hasn't done their annual minutes, it is such a hassle for the officers to fill out my checklist of various questions that should be answered. If decisions were made that year, those questions should be answered so that I can prepare those minutes. And there's always huge delays because I don't want them to disclose too much, but to find really the key things to show that a good faith effort was made, they have to really rack their brains in their records to find those decisions that need to be put forth now in writing. Important point, we can now form LLCs in all states. We are very confident of our ability to do that. And for your consideration, some states, as you know, have no income tax, Nevada, etc. Other states offer extreme privacy. But I don't want to be too optimistic on this or cause you to be too optimistic, because you're going to need to at least register your entity in California if you are going to put California real property into the LLC. So that is a limitation. California's protection is very high. The only risk is you. Whether you decide to very carefully do the annual maintenance and most important, respect the entity boundaries, not willy-nilly putting cash in, cash out, cash in, cash out. That could cause a piercing of the entity veil to get to your nest egg. So a lot of people think they can do this formation on their own. As one client recently pointed out, the operating agreement is the critical thing that you really need an attorney for, so that we can ask you the important questions, give advice, and have you make decisions to custom craft that agreement, as opposed to just taking one off the internet that really doesn't work for you. We also draft deeds, unlike tax preparers, and will set up some organizational minutes, just a one-time thing, that set forth the facts, the important facts regarding your entity. And then fancier, but super important in the right case, are buy-sell agreements. Those are, we draft those typically as a separate agreement, and they can really help protect your operations when things change with your ownership or management. And when you know in advance what kind of buyback the entity might want to do when someone dies, or that the other, well, their partners, other members / partners would like to do when someone dies or becomes disabled. We custom craft all of those. So my position is that if you own rental property, there is a very definite risk of litigation claims. The risk is real. Maybe more than any other state, the risk is real in California that you might incur a negative judgment against you. Our courts have just become increasingly aggressive against landlords. And sad to say, and you may not want to accept it, but even your friends and other tenants will be tempted, if there's a serious injury to their child, they are going to be often tempted to look to your deeper pockets for a judgment against you personally without an LLC for the significant medical expenses they might be incurring. So my banner is shield your nest egg, get an LLC. I really enjoy talking to you about it. Now, for tax issues, it's a little more complex, but not for a single member LLC. And that includes one that is just a single person or a couple in California. If you have community property that you want to fund into the LLC. So if you look over to the right, the LLC's income and expense all flows to the members, and they report it to Fed and state on their personal income tax returns. So it's very, very simple at that level. Now, choices for multi-member LLCs. They get to choose which taxation scheme they want the entity to be subject to. And FYI, partnerships are really preferred for real property LLCs. However, if you have a partnership with general partners, and there's always got to be at least one, that general partner or partners are going to have unlimited liability unless you put that partnership interest into the LLC, another LLC. But that's talking about the partnership as an entity. I want to talk about it right now as a taxation scheme for an LLC, which that's the normal or default choice, is that you'll be taxed as a partnership. You have choices though. Now let's start with the next bullet so we can discuss corporations that own real property. And sadly, I will say they cause avoidable taxes. So they're not a good choice if you have real property for your entity. But if you have a portfolio of investments, or if you have an operating company, the subchapter S corporation is the entity of choice. We'll talk more later. And again, another negative of regular corporations, that's a C corporation, is that there's double taxation. First, when the corporation receives income, and then second, when it distributes that income to the shareholders, there's another level of taxation. So that's something to be very aware of. Now, you can protect your consulting work in an entity also. And an LLC is the perfect choice for its simplicity and strength of protection of your nest egg. And then what we often suggest is that that entity choose a corporate taxation scheme, but then the subchapter S election, which gives you a nice flow through, very, very similar to partnership tax. But with the sub S, you can avoid the 15% self-employment tax. So that can be the best of all worlds. Now back to taxation as a partnership. I've already mentioned that as an available scheme for an LLC. Unlike corps, there's generally no gain or loss on contribution or distribution of real property. And there's a benefit that you can, after complying with all the tax rules, allocate to various partners income items and deductible expenses. If a particular partner might have a very big amount of income compared to the others, they might really like that deductible expense, generally in the form of depreciation deductions. So that's something to talk more about in a meeting. The other good taxation scheme is the subchapter S corporation, the good choice, very good choice for an operating business. And third bullet, I should say, there are good opportunities to increase your deductions by leasing property from the owners. It has to be reasonable for reasonable payments. And then finally, the C corporation that causes double taxation. Importantly, from the view of gifting and the upcoming very, very significant decrease in the gift and estate tax exemption, is the possibility of using an entity like an LLC, it's the best, for gifting. So how that works is the property is transferred to the LLC, and then at the right time, you can start doing discounted gifting to your children if you need to, especially to avoid that tax at 40% on your death. So it's a 40% rate, and soon at the end of 2025, the exemption for gift and estates is going to be cut to around 6 million. It increases by inflation from the current 12.9 exemption per person. So if you're in between those two, it might start to be a very, very good time to consider some gifting. The fancy way to do it, to get your discount, is to gift the LLC interests to an irrevocable trust for the benefit of your children or other beneficiaries, whoever it is. Now, this segues into Prop 19. And it's the little subtitle is Protection Against Sneaky Laws. What I mean by that is the advertisers and promoters of Prop 19, I believe, were very outrightly misleading by just discussing the good parts of Prop 19 and acting like the other parts only affect wealthy East Coast owners. Well, that just wasn't true. So this is probably a review for most of you, but Prop 19 amended two main property tax rules. Section 1 is the good stuff for seniors. Seniors over 55 can now move their home's low tax base to a replacement home and retain that initial existing low assessed value for property tax purposes. Section 2, the bad, is very, very bad. It really minimized parent-child exclusion from reassessment. So there's two kinds of property now, and have been. On the parent's home, it's now going to be reassessed to current market value unless after both parents have died, a recipient child lives there, moves in as their primary residence within 1 year of the second to die parent's date of death. So it's much more narrow now than was it before. As the promoter said, you don't deserve to rent out your parents' home for income and keep the low assessed value. You only do if a child is going to live there. So I understand their thinking there. So it's if the home is going to be a legacy home in the extended family. Of course, these children that can take are in the floodline. In the bloodline, no floodline. Excuse me. And then all other property. There used to be under Prop 13 a $1 million exemption for miscellaneous properties, your vacation home, a second home that you have elsewhere, etc. Well, that's been removed entirely. So all of that type of property is going to be reassessed to full market value upon the second parent's passing. So a little more detail on the seniors benefit. Those over 55 or disabled or the victim of a natural disaster can move from their current home to a higher cost California home and still keep their low tax base. They can do that up to 3 times in their life. Condition is you must buy that new home within 2 years after selling your current home. So I'm restating the restriction because it's very, very important to remember. A child must occupy within 1 year of the last parent's death the property as their primary residence. A lot of people forget that restriction. The little girl's got hopeful eyes, but she can't have hopeful eyes thinking about, dreaming about renting the property out for a lot of money. She needs to be willing to live there, hopefully desirous of living there. So we can assist with the details. 1, critical, have us form the LLC before you buy new property. One client even is, and for other reasons, he wanted to sell the existing property, but he's specifically doing it now so that he can make use of this Prop 19 workaround. The property is going to be in the LLC. Then you can start gifting LLC interests and retain the low property tax base so long as no one person receives greater than 50% of the LLC interests. So this is really a wonderful idea to do with a property that's going to be kept in your family for the years and decades maybe. Okay, changing subjects. We're going to talk for a minute about the Corporate Transparency Act. We're watching out for you and we want to tell you about it, although we don't have all the details yet. So it was adopted a few years ago. The goals are to fight financial crimes and fight terrorist financing, which is always very, very valid and important. The other 2 are just protect against bad actors doing bad acts, tax evasion and money laundering. So none of you are in any way involved in any of that, I am positive. But I want to look at the seal over on the left so you'll know about this relatively new agency of the US government, specifically under the Treasury. And the bottom half circle says Financial Crimes Enforcement Network. That's abbreviated now as FinCEN. And they've got a lot of good goals. I fear that this law might be a little overreaching. So it requires previously unregulated companies, i.e. those not under the SEC, Securities and Exchange Commission regulation. These smaller companies must now provide information about the company and about the owners, which has never been done before. Who is affected is corporations, LLCs, family offices, and all entities that are created or registered to do business by filing a document, generally with the state Secretary of State, in order to form. Possibly included are partnerships or even limited liability partnerships, like a law firm, some unusual business trusts and statutory trusts. But the exemptions are, as would be expectable, the SEC companies, banks, exempt organizations, and the government. Now, also exempt are large companies with 20 or more employees and gross receipts of 5 million or more per year. So that's going to possibly affect some of you in that gray land between transparency coverage and SEC coverage. which is a great place to be for right now. Company reporting is required. Beneficial ownership reporting is required. And that only reaches down to those who own or control 25% of the entity, or alternatively, receive very large economic benefits from the company, generally in the form of salary. Now, what you have to disclose is what's most ominous. And you're going to expect these first three, but the most ominous one is the bottom bullet. Photo ID with ID number shown and your picture shown. I need to add that to the slide. That's what's never been required before at the federal level. And I pray that it won't be used for nefarious purposes to know what you're doing. So the deadlines are for existing companies, you have until January 1, 2025. It's a while off. If you don't file by then, you're going to face large penalties. But this is not going to apply to any of you. Either you'll file this or you'll have us assist. And the fine is for those terrorists who are unwilling to comply. Terrorists and bad actors. There's huge fines of up to $10,000 and prison. So for new entities created after or beginning at the beginning of 2024, they will have 30 days to file after they are formed. So we will direct you in that formation for next year's entities. Okay, now we have some case studies that I hope are going to bring some of this home for you. And Sherlock is asking, have you thought about, here's a really bad example, but a drunken tenant, maybe walking upstairs that had the rickety looking stair railing, something like is shown on the left. So the pattern is going to be in these studies. The tenant is injured, or the tenant's friend or invitee to the property is injured. A lawsuit filed, property owner found it at fault, no LLC formed for these first few, but it would have provided protection because the landlord is protected by that shield of the LLC entity that's been well maintained and properly formed in the first place. Okay, case number 2. The rental property's home front door didn't latch properly. The tenant's aggressive dog escapes, runs several blocks, and bites someone very seriously. So we're back to the pattern of injury to the victim, lawsuit filed, landlord found liable, no LLC created, but it likely would have provided protection. I think it was a bigger, nastier dog than this one pictured. The malpractice suit against a doctor. A patient was scheduled for surgery. There was unforeseeable injury to the patient during surgery. Praising the Lord, the patient survived, but was no longer able to work and gain a salary. So lawsuit filed, in this case for a lifetime of lost or minimized wages, but this was for lost wages. Doctor found liable for negligence, LLC created but improperly using an internet couple of forms. That LLC provided no protection. Heaven only knows a doctor should have respected another profession in the law to have this done properly. Case study number 4, slip and fall on the rental property. A properly formed and maintained LLC was in place. A person, it really doesn't matter if they're the tenant or another, slipped and fell on the property. So the standard pattern, injury to the person, lawsuit filed, But something new, owner removed as defendant in the case. That's the praise. The LLC ended up being held liable. The LLC property was indeed taken to satisfy the judgment, but not the landlord's nest egg, which was not touched. I want all of you to be in this category. So beware, do it yourself. DIY. Having a non-attorney form your LLC could result in no protection at all, and even penalties and interest, usually imposed by the Franchise Tax Board, our state taxing authority. They got no professional advice in creating or maintaining the entity. I'm sorry, that should be really having a non-attorney form the LLC, provided obviously no wise professional advice. The cheaper option ends up costing more later. And worst of all, the exposure isn't discovered until you're in a lawsuit, when it's too late. Oh, well, I should have finished up there. So I'm glad you're listening to this today. Don't let it be too late for you, I ask. So how we can help you. I'm talking about basic estate planning here. Consider what matters most to you. What do you want to share with your loved ones about your life and legacy? We've got a variety of ways that you can do that, even outside your trust and will. We do family legacy recordings, if you'd like, with some well-posed questions, and your responses can just be a beautiful thing for the next generation to watch later on. You always need to determine and redetermine the responsible successor trustees, and maybe some tweaks are necessary on the beneficiaries named in your revocable trust. It's very good to come in for an analysis and review every 3 to 5 years at least. And I suggest that if you have some LLC-able property, you specifically mention your desire to minimize taxes and reduce your risk exposure to the estate planner. And they'll often refer you over to me to talk a little more deeply. You should use qualified professionals, I suggest. It's the very best when you can have your attorney, your CPA, tax preparer, and even your financial advisor involved in determining whether you should form an entity and discuss what kind of tax law you want to apply. That professional needs to understand specialized planning. So many don't, who are just used to doing your personal income tax returns. And intelligently add custom provisions is what attorneys can do. Generally, only attorneys. So you'll know what needs to be done and when, as will your family and your children. We can give you the tools to take care of your family. So discuss these things while you're alive and well. That is the time. You can always tweak them later on. Operating agreements are very amendable by the members. And of course, review and maintain your estate plan. So my reminders are: protect your nest egg with an LLC, always buy new real property into an LLC. And finally, which we haven't gone into depth on today, consider a foundation or charitable remainder trust. If you have some appreciated property you don't need and you dislike capital gain tax, come to my CRT Foundation webinar that's going to be recorded soon. We'll discuss those. For now, I warmly invite you to schedule time with me. And here's some more about Kopenbarger Law Firm. We've got a lot of longevity from when Lloyd started the firm. We have 8 full-time attorneys, 2 attorneys of counsel, and I am certified as a CPA. Together, we have over 350 years of combined experience and several advanced tax degrees, including me, certified specialists in probate, estate planning, and tax trust law, 45 highly qualified support staff, who you saw earlier. We've got diverse staff and with diverse skills, and 8 office locations, and we're all willing to do Zoom if needed, a Zoom call. So I want to advise, you will be receiving an automated phone call from us after this webinar ends, asking if you were interested in setting an appointment, either with me, my department, for an LLC or other entity, or any of the estate planners. Or, heaven forbid, perhaps our trust administration department, if your parent or another relative has passed away. We're here to help and look forward to hearing from you. You can call us anytime, visit our kopenbarger.com website, email us. And in addition, I would appreciate a digital evaluation of this seminar. I'm the newest attorney to be giving these, and constructive feedback always helps. So thank you in advance for considering doing that if you have time. It was great spending time with you today. Thank you very much for your attention, and I look forward to hearing from you at your convenience. Bye for now.